Okay, we all set? Thanks to everybody for coming out. So unfortunately, one of our panelists, Mr. Levine, was unable to make it because of a family emergency. So it's going to be a solo act today. But, sometimes that can be a good thing, and we can get into a little bit more detail. So I wouldn't worry about that. Unfortunately, we've got a very experienced presenter. So actually, my first job was to tell you that Mr. Levine's not going to be here. My second job is to tell you that CLE materials are available online, so you can download those. And then my third job is to introduce our speaker. Kenneth Angeron is here to speak to us, and he's the president of Brown Sims PC in Houston. A very experienced presenter for nearly 40 years. He's lectured on legal subjects, University of Texas, here, LSU, University of Houston, Louisiana State University, Loyola University, and others. Written extensively, long publication list. And so with that, I think I'm going to introduce him and let him fill up any gaps himself. Mr. Angeron.
Thank you. It's a pleasure being here today. What we're going to talk about today is going to arise primarily out of the Deepwater Horizon. We're going to talk about some of the environmental issues that came up, and particularly as those affect somebody like Anadarko. Talk a little bit about BP, Transocean, all the parties, but we're also going to talk about specifically those people who consider themselves to be investors who then become polluters. So I would start off, particularly for our good young people. Some of our older people probably don't spend a lot of time down on Padre Island, South Padre. Anybody been to South Padre? A few spring breaks there back when you were younger, things like that. It's really nice. Beautiful water, nice beaches. They have white sand as opposed to around here or in the Houston area or so. But all that changed in an instant. Back in June of 1979. For those who, some of you may not have been around back in June of 1979, but for those who were, that was the Ishtok well, which blew out down in the Bay of Campeche. Oil spewed out of that well into the Gulf of Mexico, not for 1 month, 2 months, 3 months, for almost 10 months. And it spewed at times at 30,000 barrels a month. So it was a tremendous environmental catastrophe. The estimated amount that was spilled was about 140 million gallons, which is still in the water the largest spill, even eclipses the Deepwater Horizon. It covered an area that was about 1,100 square miles. And it was finally capped, as I said, almost 10 months later. And for years, if you went down to South Padre after that, the beaches were just covered with terrible tar balls for years and years and years. In fact, if you go into places in, say, New Orleans, you go into a hotel or a place, you might find plastic bags there for your umbrella. Same in Houston because of the climate that we have down here. All the places had plastic bags back in South Padre because you had to take your shoes off before you went in anywhere if you'd been anywhere near the beach. So then comes April of 2010. And you have 3.19 million barrels of oil, over 130 million gallons. Now, by way of comparison, you all know the Exxon Valdez. The Exxon Valdez was 11 million gallons. It's about 1/12 of what the Deepwater Horizon or the Ishtak wells were. So with that, since what we want to do is we want to focus on, when we get one of these disasters, who is liable and how much they're liable for. So we need to stop for a minute and we need to talk about who are the parties who are involved. So we have to start there. And many of you know Chief Judge Brown, who was my mentor back in 1975. He characterized the operations offshore like the Macondo type of well. He characterized those as multi-party Donnybrook fairs. And that's really what they are. And so we have to look at that for just a minute and think, because we have to understand how the environmental laws work in the context of the roles of the parties. So who are the parties and what are their roles? And we have to start with the operator. The operator is the one who owns the lease. They've gotten the lease offshore from the United States, so they actually own the oil in the ground under law. They actually own that oil. That's their oil. And because of the expense of operating, they're frequently doing that with non-operating partners who don't have anything to do with the day-to-day work on the well. They approve an expense, and then the operator goes out and does all of the work. And in the Deepwater Horizon, BP was the operator in control of the well. It's their oil. But they share that ownership, but not operation. They share the ownership with Anadarko, who has 25%, and with MOEX, who has 10%. BP has 65%. And so they then engage all of the people who go out there and do the work of the drilling. And those include the drilling company. And the drilling company is important offshore because it's their rig, and if it's a freestanding structure, it's going to be a monster vessel that, in the case of the Deepwater Horizon, is worth somewhere over $700 million. So, and it's hard to say exactly what its net worth before the accident was. We certainly know what it was after the accident. But it's somewhere between $700 million and $1 billion. So nobody can say that Transocean, the owner of that, didn't have any skin in the game. They certainly did. $700 million worth. And then you have all of the service companies who are out there working as well. And those service companies include suppliers of the BOP, the blowout preventer. Cameron in this particular case. You have people who provide important services like providing the cement to complete the well. In this case, that's Halliburton. You have all sorts of other people who are involved in operations, casing companies, wireline operators, fishing companies who are involved in the actual drilling operation. And then you have all sorts of other contractors out there. If you've ever looked at an offshore installation, there isn't just a platform or a drilling vessel out there. There are always vessels going to and from, loading, unloading equipment, transporting people, and the like. So you have a veritable city out there with numerous contractors, hundreds of people involved in some of these operations. Now, over 60 years ago, easy to remember because it was in 1952, which tragically happens to be my birth year as well. Companies came to a general agreement on how they were going to allocate responsibility. And that's, from a legal perspective, that's actually good and bad from a legal perspective. If you're a company and you face massive exposures for environmental damage, loss of people, loss of property, cleanup, re-drill, loss of hole, all those kinds of things. One of the things that you want to do is you want to allocate that responsibility in advance in a sensible way, in a way that's fair and reflects economic rationale. You want to do that so that then when all hell breaks loose, you're not all litigating against each other, pointing fingers, and instead you've got it all allocated so that you can have a complete, good, unified defense against those claiming against you. And so they figured, it took years to figure this out. It took over 30 years to figure this out. But they finally figured out, oh, that's through our reciprocal hold harmless agreements. That even though that meant that somebody who may not be at fault, who may be at fault, may be partially at fault, whatever, it replaces that finger-pointing allocation of fault game with one where it's been determined by contract in advance. So one of the problems that does is that takes a lot of work away from lawyers. Okay, so as I said, it's not all good. Because it means that instead of fighting with each other and all trying to lay blame on each other, that you're only fighting with the people who are making claims. So it's good and it's bad. It's really good for the companies and their insurance and the world, but from a lawyer standpoint, it's not as good. So we have to look at this from a positive and a negative side. So how did that allocation work? It was easy in areas like property damage, injuries and whatnot. Everybody takes his own people, his own property and the like. For environmental issues, it isn't quite so easy as I take my pollution, you take your pollution, because many of us may have some sort of contribution to it. But on the other hand, it does work. If you look at the source of the pollution, and that's the basis for your allocation. And so the parties figured out that if you divide it up, it comes to both economic justice and fundamental fairness as well. And that is that the operators, the oil companies, agreed to take all of the pollution, all of the liability for the pollution that arises below the surface of the water. In other words, from their oil. And all of the contractors, whether it's the drilling contractors or the Halliburtons or people like that, the cement companies or things, they take the pollution that arises from their equipment, their goods, their services above the surface. So, for example, if Halliburton throws some mud, which is full of heinous chemicals, overboard, then Halliburton's the one who's got to pay for it. If the drilling company, if their machinery has a problem and leaks fluid into the ocean, then that's the drilling company's responsibility. And so, if it comes from the well, then not only does the oil company have to clean it up, remove it, control it, stop it, but pay for the loss of hole, the re-drill, the loss of oil, the loss of production, the loss of profit, and all of those things. Now, when you think about this, sometimes for those who do contracts involving the industry, sometimes it can seem a little bit oppressive to each one of the parties. For example, because the oil companies don't have more than one or two people off there at any one time that are theirs, almost all of these claims for injury and damage and whatnot are going to be paid for by the contractors who have to hold the oil companies free of fault. And so they get excited and upset about it. And they even ran to the legislature in Texas back in the early 70s, and they ran to the legislature here in Louisiana in 1981, and they said, oh, anytime somebody has a hangnail, we have to pay for it, we have to hire lawyers, our insurance is just awful. And the oil company said, yeah, okay, but what happens if you have, because Ishtok had just occurred, what happens when you have a blowout and it's your fault? Are you going to pay hundreds of millions, and I'll read you a quote in a minute, hundreds of millions of dollars for the cleanup, for the loss of our oil? You going to pay for 130 million gallons of oil? You going to pay that? Where are you going to pay that from? And so it actually fits nicely into an economic and fairness sense. The president of one of the major drilling companies at the time explained the bargaining when the Louisiana legislature had proposed, by some of the contractors who'd gone whining to the legislature, they'd proposed banning all indemnity. Proposed banning it all. And this is what the president of the company said, because I was sitting next to him at the time. Thus, the indemnity we must supply to the operator, while being an administrative burden, in no way threatens the financial position of Huff Nance Drilling. What threatens us is the potentially devastating losses from a major blowout in connection with pollution and loss of oil. An example is an incident such as the Bay of Campeche blowout, which had just happened 2 years before this. In the event of a large spill with pollution damage, loss of oil, and great expense to control the well, a contractor could not begin to respond in damages. The insurance to cover these items is not available in the market. In a major disaster, the damages for pollution and cleanup would run into the hundreds of millions of dollars. That's 1981, and all I can say is that's amazingly prophetic except for one thing. That was 1981. It was hundreds of millions in 1981. Now it's tens of billions of dollars. And it's still out of reach. And there is not capacity in the insurance market to pay for it. And in fact, BP didn't insure it because BP couldn't even get insurance for this. There is not enough capacity in the market. Has to be self-insured. So they begged the Louisiana legislature, don't do this, but the legislature then made it a win-win for the little contractors and punished the oil companies by giving the contractors the best of both worlds. They said, we're going to ban indemnity for injury claims where you have to pay it all the time. But we're not going to ban it for environmental claims, property damage claims. So that indemnity, the allocation that has happened since the beginning of time, 64 years here now, that allocation is still good. So what about not just the industry reality, but what about fairness? So the contractors supply equipment. They have skin in the game up to the value of their equipment, their rigs and the like. But who has the real skin in the game with respect to the billions of dollars of oil? And that's the operator and the non-operators according to their percentage. The contractors have no financial interest in the well and its production at all. The owners and operators get the profit from the oil and gas. So it's only fair that they are responsible for the cleanup and the pollution, the damage, the loss of hull and the like to their hull, to their oil, and from their oil. And they're the only ones who can afford to clean it up and who have the equipment to clean it up, and so can respond instantly when there is an accident. And so putting the responsibility on them when they have the capability to do so is one not just of fairness, not just of economic reality, but one that then benefits the victims of pollution as well. So let's look at the Macondo well. BP, Anadarko, and MOEX. BP, the operator, Anadarko, 25% of the oil, MOEX, 10%. Okay. So BP, the operator, they're responsible for doing all of the work. It's their responsibility. Anadarko and MOEX are not allowed to participate. They're not allowed whatsoever under the operating agreement. So BP enters into the contract. They enter into the contract with Transocean. Transocean supplies its vessel worth more than $700 million through a drilling contract that allocates responsibility in accordance with the traditional allocations that have been in existence for the past 60 years. The blowout occurs after drilling is successful and the well is being prepared for the departure of the rig. When the cement failed, the blowout preventer failed, fluids burst from the well through the riser up through the deck, ignited, and caused the blowout. The riser was then, when the rig collapsed, the riser was severed, and for 3 months oil poured into the Gulf of Mexico. It poured through the severed riser and blowout preventer. Now that leads to a number of environmental questions, which we're going to talk about here today now that we have the whole background to this. So the first question is, we've got environmental legislation, we've got the Oil Pollution Act of 1990, we've got the Clean Water Act, which was amended when OPA was enacted in 1990. And so the question is, let's talk about penalties. Because the penalties are potentially extremely severe. Those penalties are found in the Clean Water Act. And so the question is, who's responsible under the Clean Water Act? Now, for those who know a little bit about admiralty law and environmental law, you know that admiralty law is completely different than land law, in the sense that the law of admiralty was created by judges. It has been in existence for millennia. And in our current form, it's been in existence for about 8 to 9 centuries, made by judges. And in fact, there is, when you get onto the water, where admiralty law has had principles for everything for millennia, there is not a single environmental judge-made rule, not one, in admiralty until 1969. It is the absolute converse of all of admiralty law. Admiralty law on the environment was all by statute until 1969. And those statutes arose, amazingly, in the 19th century as our shipping developed with the Industrial Revolution. The judges, the admiralty judges, did not react. They reacted if seamen were hurt, if longshoremen were hurt, if ships collided, if there was damage to cargo. We've had general average principles since the Phoenicians. Yet in admiralty, there's not one case until 1969 involving admiralty common law. All by statute. So it's exactly the opposite. So they're the exception to our general rule of man-made law. And the rules came through statutes. And so that takes us to the Oil Pollution Act, the Clean Water Act, statutory enactments without any legislative overhang over them in any way. So the Clean Water Act then does provide penalties. It provides civil penalties and it provides criminal penalties for pollution of navigable waters. So now I'll get into the actual text of it after noting that the United States pursued penalties against, of course, everybody they could think of. They pursued them against BP, Anadarko, MOEX, and Transocean. Ultimately, they settled some before and some during and some after trial, but they settled with everybody except Anadarko. MOEX and Transocean settled with the government. Transocean paid $1 billion for its civil penalties and $400 million for criminal penalties. BP settled its criminal liability for a total package of $4.5 billion, including the penalties. MOEX, 10% innocent, non-operator, paid $90 million. 10%. It left for trial Anadarko and BP's civil liability. So the question is, now, we get into two different issues. First, under the Clean Water Act, who's responsible? And then second, how do we determine what those penalties should be? And by the way, I should have said this at the outset, I love questions. I love questions. And this is your lecture. So anytime you got a question, just put that old hand up. All the questions are great, and I do love questions. So,
Quick question. Does your firm represent one of the entities that are involved in this litigation?
My interest was on behalf of the International, and I should have said that, the International Association of Drilling Contractors, who supported Transocean. And so I wrote all of the amicus briefs on every issue in the Deepwater Horizon for the drilling contractors to protect the interests of drilling contractors. Everything from who's liable under the Clean Water Act, which we're about to talk about, to whether drilling contractor is an additional, whether the operator is an additional insured on the drilling contractor's insurance. That was only a $1 billion issue on that one. And so, yeah, I did all of the amicus briefs, but my good friend from representing Anadarko, who is not here, I'm going to give, trust me, I'm going to give Anadarko's position as well. Mm-hmm.
Could you comment on the wrongful death liability of the 11 people who were killed?
The wrongful death liability. That's kind of a 5-6 hour lecture. Do you have a little narrower question?
Death settlements.
The settlements?
Workman's comp.
What would you like to know? The amounts? Would you like to know whether they were appropriate? Would you like to know what they recovered?
No, just who paid them and what was the employer?
They were paid. That's a good. If you're talking about the allocation, they were paid in. Unlike BP, so I'll be very straightforward with you, who refused to abide its indemnification agreement, all of the contractors, Transocean had the most, obviously, Halliburton, Weatherford, and the like all had people who were injured or killed. Each contractor paid the settlement and then took out all the liability of everybody in accordance with their contractual liability. Those liabilities arose under the Jones Act, the Death on the High Seas Act, and the Longshore and Harbor Workers' Compensation Act. Anything else you'd like to know about those? Mm-hmm. But that was, one second, that was a very good question because it shows that some people live up to their contractual obligations and some people don't. And I told you who did not. Yes, sir.
This goes back to your discussion about Ixtoc. My understanding was that the Mexican government and Pemex refused to pay anything towards the cleanup for the Texas coast, claiming sovereign immunity.
They did, and they got away with it.
So who actually did pay for it? The Texas...
Paid for what?
Cleaning up the beach.
Yeah, the state and local people. Yeah, in case you didn't hear that, the question was, problem being next to a sovereign neighbor here in Ixtoc who paid for then the cleanup along the coast because Pemex, the sovereign contractor, and the Mexican government declined to pay anything, so it was up to state and local governments to pay. Mm-hmm. Yeah, not like here in the U.S. of A. where our environmental legislation is quite strong. So, okay, so now here is what is said about liability for the fines and penalties. The owner of a facility or vessel, and here's the key, from which oil or other hazardous substance is discharged. So, what we're looking for is what is the source from which the oil was discharged. Okay. Well, we're helped, maybe we aren't helped, by the definition of discharge. So what is discharge? Discharge is spilling, leaking, pumping, pouring, emitting, emptying, or dumping. So, from whence was it discharged? And that means where was it spilled, leaked, pumped, poured, emitted, emptied, or dumped? Okay, so let's think about this now. The well belongs to BP, Anadarko, Moex. It's their well, it's their oil. And when the rig collapsed, you know what a riser is? I use that term. You know what the riser is? So the riser's coming from the well, and the oil's coming out of it. It breaks off. So it's going through the BOP and the riser, just a few feet of the riser, and pouring into the Gulf. Now, we know the well is where the oil's from, but it's going through the BOP and the riser, which are appurtenances of Transocean's vessel and belong to Transocean. So is this discharged from the well, or is it discharged from the riser? Now, the good thing for the U.S., you got to love being the United States. They get to say whatever they want because they're the big guy. And so they said, it's all of them. Because discharge is a process. The discharge starts in the well, and it continues through the BOP and the riser. So everybody is liable. And we can penalize everybody civilly and criminally. Yeah, I love the government. You got to admit. So the question is, Anadarko and BP say, well, discharge means the last thing it came out of. And Transocean, of course, says, whoa, this is the same thing the industry has been saying for over 60 years. It's their oil. It came from their well. And the district court then came up with its answer. And Judge Barbier's not here to explain, but it sure looks like he decided to come up with and the good thing is, there's no case where this has ever happened, so he's going to make up the law. So it sounds like he and the panel of the Fifth Circuit that we'll talk about in a minute decided that they thought that it was BP and Anadarko. And so the test that he came up with is the discharge occurred where the uncontrolled movement of oil began. Where the uncontrolled movement began. It didn't begin in the BOP. It didn't begin in the riser. So it had to begin in the well. So the responsible party for penalties is not Transocean. They're off the hook. But as you saw, I think they were worried enough that they settled their civil and criminal liability for $1.4 billion. I think they thought it might not be completely cut and dried. So,
when did they settle?
They settled after the decision by Judge Barbier, but before it went to the Fifth Circuit.
Just as a clarification here, though, Judge Barbier did say in that opinion that Transocean, if they were determined to be an operator of
right.
the offshore facility, they
Correct.
may be liable. So they were not all scot-free. It was just that was issued.
Right, they're not off scot-free, but that's highly unlikely. That was a remote possibility that was...
They were found to be an operator in the
Yeah.
findings.
Correct. So the next point is then, the district court obviously is influenced by public policy here. Because public policy, the purpose of the penalties is to be borne by those who are engaged in the enterprise that caused the spill and stood to make the profit from it. And that BP and Anadarko. And there are practical considerations, too, that he considered. You shouldn't have a decision that depends upon the fortuity of where the riser breaks. So, if we don't have a situation, if the rig collapses and the oil is not coming through the riser, then it's BP, but if it breaks 1 foot into the riser, then it's Transocean. And there's some degree of fairness to the fact that the oil did, as the industry is allocated for all these years, emanate from the well owned by BP and Anadarko. Now, as I said, Transocean settled, so that issue is not before the Fifth Circuit, although the IEDC did file their brief to say it ain't Transocean, it ain't the contractor here, it's the well. Now, Anadarko made a number of really good points on appeal. First, it noted that they're just a 25... Look, we're just an investor here. You know, we're just a passive investor. We put 25% of the money in. We didn't have anything to do with this whatsoever. BP conducted all the operations. Anadarko conducted no operations. They exercised no control either. They made no decisions on control of the well or design of the well. BP chartered the Deepwater Horizon and made all the decisions with Transocean. And they had no control over choosing Transocean or the Deepwater Horizon. Now, as to the actual substantive law, Anadarko argued two things about the loss of confinement test by the district court. One, it's wrong, and two, it's misapplied. They argued first that discharge should be the last thing, saying to the district court, where the oil passed into the environment. Because how can there be a discharge unless it's going through that riser? So where is it discharged from? It's discharged from where it enters into the environment. That's where it went out, from a closed system into the environment where the pollution occurred. There's no pollution until it left the riser. And then they said, look, if you've got any question here, since these penalties, even though this is a civil penalty, we got to look at the rule of lenity. If there's a dispute about how to interpret this, you have to interpret it against the government and in favor of the party from whom penalties are being sought. And then on this argument, they came up with some practical considerations that I thought had some appeal to them, some visceral appeal to them. So let's take something that occurs every minute of every day across the United States, and that's transportation of oil by pipeline. And in this great state, as well as in across the Sabine over in my home state of Texas, we got a few pipelines going. So, okay, you've got oil coming from Louisiana or Texas, and that is pumped across state after state after state. And then there's a leak in a pipeline over here in Massachusetts. Are you saying that it wasn't discharged in Massachusetts, that it was discharged in Louisiana? So the next thing that they argued then, you got to admit that's got a kind of a visceral appeal to it. The next thing they argued is, okay, even if it's the loss of confinement kind of argument, where did that occur? Where did that occur? Because we've got the loss of confinement. What's the purpose of having a BOP out there? What does a BOP do? Isn't that supposed to confine the oil? Yeah.
About the BOP, was the Bureau of Ocean Management in any way responsible for the fact that they only required one, and the failure rate, according to their test, was 37%?
Yeah.
If you looked at the Tuscaloosa trend, the reason the drill index was 6 stories high is because they had 6 BOPs between the deck and the ground. And, so on land you have access to a lot of things. 5,000 feet deep you don't. And I would wonder why they didn't require 3 or 4 or more BOPs as backup for the backup.
Well, if you're asking, is any government agency responsible for anything? Of course not, because they're the finders of fact. And so they can't be responsible, and will not be and weren't. And interestingly, Cameron was exonerated on summary disposition. So now, the IADC opposed Anadarko, and on behalf of Transocean, and argued that, in essence, the Clean Water Act codified the responsibility of oil that's emanating from the reservoir and the well compared to oil that is on the surface that originates from the contractor's equipment. And they made this point that I thought was good. The term in the industry that you hear all the time is you hear of well blowouts. There's control of wild well. Have you ever heard of a riser blowout? Or a BOP blowout? Or how about control of wild vessel? So the panel of the Fifth Circuit agreed with Judge Barbier and his test. They purportedly agreed with it the way he phrased it, which was the loss of control. But the definition is, as modified by the court, was not where the uncontrolled movement began, because that then Anadarko challenged the question of where the uncontrolled movement began, because the uncontrolled movement began not in the well but in the formation. So if you're actually talking about where it began, then maybe God's responsible. And so the thing is, I don't know that we want to find God under the Clean Water Act. I don't know, you serve the Pope or what. But in any event, so what they did was, it morphed, without saying that they changed the district court, it morphed a little bit so that it would, once again, choose to pin BP and Anadarko. And so it's now where loss of controlled confinement occurs. And that is at the cement where we enter the reservoir. And so that occurs in BP and Anadarko's well. And so our test is just ever so slightly more so that they can be liable. Now, I would note that Anadarko and BP strenuously pleaded for rehearing en banc, and the court decided 7-6 against rehearing en banc. 2 judges recused, the 6 conservatives all voting for BP and Anadarko, and the 7 moderates and liberals voting for the government. So the Supreme Court then refused to hear the case. Cert denied, even though BP and Anadarko had briefs from everybody from the Queen on their side. And Supreme Court wasn't impressed with the Queen. Now that we know who's liable, let's talk about what are appropriate penalties. So there were 3 trials. The liability of the parties. Anadarko was exonerated. Any fault. BP was assessed 67% negligence and found grossly negligent for conscious disregard. Transocean was found 30%, Halliburton 3%. So BP is liable not just for civil penalties, but they're liable for criminal penalties as well, and enhanced penalties as civil penalties. BP's already settled their criminal penalties, but they have enhanced civil penalties that they have to pay, and Anadarko has regular civil penalties to pay. The Phase 2 trial determined how much oil was spilled, 3.19 million barrels. And so the fine that Anadarko faces is a potential of up to $1,100 per barrel, which is $3.5 billion. And BP could be liable for up to $13.7 billion in fines. So the United States argued that the judge should, and we'll talk about these factors here in our last part of our presentation. The United States argued the judge should fine BP not quite $13.7 billion, maybe just $12 billion would be a good number. And they said that for Anadarko, something more than $1 billion, but less than the $3.5 billion. And BP settled then for $5.5 billion in a package for their settlement. So now let's turn to the issues here, remembering once again that Anadarko's main argument here that it's going to use, and we'll look at these one by one, is that as a passive investor, it's without fault. It's not at fault here, so why should we give anything other than just a nominal penalty? And the answer is, you got to get this fault crap out of your head. Environmental legislation, like workers' comp, we're talking social legislation. This isn't a common law remedy. The common law, the whole purpose of the common law is to try and come up with a fair, fault-based resolution between people. That's why you have liability. That's why you have contributory negligence and the like. It's trying to allocate what's right between the parties. Social legislation has nothing to do with what's right or what's fair. Social legislation is who had the power in the legislature. That's all. If you don't agree with your assessment of fault, you argue on appeal that it was wrong. If you think if you disagree with social legislation, you don't go to a judge, you go to the legislature and you say, I think the workers' comp premiums are too much. I think that you ought to pay less in disability. The unions come in and say, no, you need to pay more. And the legislature decides who's got the greater power and they pass the law. And so you can't look at this from a standpoint of, oh, let's be fair to these people or let's be fair to these people or whatnot. No, that has nothing to do with it. If you don't like it, go to the legislature and bitch about it. That's the way it works. So now, what are the factors that we use to determine this? This is a penalty, guys. So here's the point about a penalty. A penalty has two purposes: punishment and deterrence. Now let's look at those factors, and Judge Barbier did a really good job of this. He did a really good job of looking at these, particularly considering what the factors are. Number one, how about the impact of the blowout or spill, its seriousness? Okay? So we had over 1,000 miles of shoreline that had a devastating impact here. We had 11 deaths. We had damage to the economy, to tens and thousands, and if you look at the claims, over 150,000 people and businesses and the like. Now, in its behalf, BP had a tremendous response. An absolutely tremendous response. It's enormous. There's never been anything like it in history. And it prevented damage to a much larger area because of their amazing response. But Tony Hayward, who put his foot in his mouth more than once from his yacht, CEO of BP, admitted, kind of hard to go back when he says it's an environmental catastrophe. That kind of stuck with that. But I think you got to admit that's true. Anadarko's smart. And they're not led by Tony on his yacht. They admitted the spill was extremely serious and went right on. You're not going to win that argument. Might as well go on and make your points elsewhere. Now the government responded, interestingly, that yes, it was serious, but it could have been a lot worse. So when you talk about seriousness, yeah, this is an environmental catastrophe, absolutely. But don't forget, it could have been much, much worse. And you need to think about that too. The economic benefit of the violator is one that is an important one, particularly, as you know, from the Citgo case from the Fifth Circuit, for those of you who've studied that. Because the one thing in environmental legislation that we don't want to do is allow people to profit. Allow people to profit from bad practices. So if you skimped on and did a bunch of negligent substandard acts, then you need to, at a minimum, the baseline for how much your fine or penalty should be. The baseline should be what you profited, and then go from there. And so, interestingly, that was actually, we talk here in a minute, quantified by Judge Barbier. Now, culpability is a factor. Because one thing you want to do is, for people who have serious fault, then you want to see that their punishment is greater than not. Anadarko plays up. We're an investor. We are a mere 25%, not even a majority. We just had 25% of this and we did nothing. And so Judge Barbier has to agree they have no culpability, and so that's not a factor that's going to add to the penalty. Then you look at other penalties for the same incident. Transocean, 30% at fault compared to none for Anadarko, paid $1 billion in civil penalties. BP, $5.5 billion in its package for the civil penalties. MOEX, $90 million for 10% for its package in connection with settling out the penalties. You look at the history of prior violations, Anadarko didn't have any that were relevant to this because Anadarko wasn't the operator. It had a host of small ones, a gallon or two where it lost, where it was fined $250 or $500. It did have one serious penalty for $1 million, but it was unrelated. You look at mitigation efforts. What did Anadarko do here? Sure, it's the non-operator. It has no duty. It has no duty. But it didn't do much either. And what it did is, out of the 90,000 people, how many did it do? Was it like 5 or something? It gave 5 people for 3 weeks. And gave a couple ships out of the thousands of vessels that helped in the cleanup. And then, they then charged BP for helping out. And that was not lost on the court. So for everything they did, we really tried to help. Yeah, and so we've sent BP a bill for it. That's not smart. Okay, that's not smart. That's not smart. So you look at the economic impact on the violator. Now this is a tough one for Anadarko, because Anadarko freely admitted it could pay $4 billion. So with the potential penalty of 3.5, that's now BP made a big plea and said, our subsidiary, our operating subsidiary that's the liable one, they can't pay $13 billion. They can't do it. And they made a real plea, look, can't get anywhere close to that, even though BP could pay it. But not the actual subsidiary that's the operating subsidiary. So one of the things you have to understand, though, is when we talk about the amount here, that's a two-edged sword. Because, yes, if I can't pay, then certainly the amount of the penalty should reflect that. But on the other hand, if you're a big evil corporation with lots of money, then it takes a real slap to get your attention. So somebody who can pay, there's an argument that they should be fined more than somebody who can't pay for the identical circumstances. So Anadarko's got to walk a real tight line here. Okay. Now the last factor is other matters, and this is where Anadarko makes its best points. The oil and gas industry is watching this case. They are. Because how people contract, where they invest in oil and gas is going to depend a lot on whether, if I am an innocent party, I want to pay 25% of these expenses for this well, and then the next thing I know, I've got a $3.5 billion charge. So that's going to make you think a couple times about whether you're going to invest or not. I don't know if y'all have $3.5 billion lying around. I don't. And so before I invest thinking I'm going to make, $300, $400, $500 million in profit, or maybe $1 billion in profit, knowing that I could get stuck with $3.5 billion fine, might make me think a couple times about that investment. Okay, so now let's see how Judge Barbier resolved that, and we'll be finished. Seriousness. I don't have to talk long about that. It doesn't matter whether you're at fault or not at fault. This is as serious as it gets. And so he says that merits the largest fine possible. Period. No questions asked. Hard to argue with that. Pretty fair reasoning. The economic benefit, which is really an important issue in the Fifth Circuit, because they reversed that Citgo case because the district judge didn't find enough analysis of the economic benefit. He finds that the economic benefit that they had by the savings that caused this was probably about $3-some million. But Anadarko had already paid in a settlement $4 billion to BP, so the baseline has already been kind of met. They've already lost $4 billion, so that doesn't merit any further punishment to them. Culpability, not a factor here, not something that we want to add anything to. It's kind of neutral. Okay. Now, Judge Barbier does talk a little bit about the mitigation efforts again there, kind of throwing in another barb at them for the fact that, yeah, they weren't part of it. They weren't asked to be part of it. They didn't become part of it. And then when they did volunteer, they charged for it. And so he gives them a little dig for not being a bigger player here. His quote is, "They came kicking and screaming to the response." That's what Judge Barbier says. The one that kind of Judge Barbier thinks is important is the last one. And though he did not completely disagree with the general premise of Anadarko's argument, he did disagree on the amount of the penalty. And Anadarko said, there's one thing that we need to understand here. And that is that this isn't just going to cause a lack of investment in the oil and gas industry. This is actually going to discourage safety for two different reasons, and we don't want to discourage safety. And here's why. Number one, up till now, the operator is responsible. The operator is completely responsible for safety. So now, if you say that non-operators, all these investors, are also responsible for safety, then you're going to have such cross purposes that it's actually going to be deleterious to safety, because Anadarko is going to say, no, we need to do this. No, BP, no, we need this. And MOEC, no, it's got to be this. You need one person speaking so that there is clarity, so that everybody's on the same page. And so Barbier buys into that a little bit. And the other thing is that if you've got all of your investors also paying, then that's a disincentive for the number one operator to be giving its best efforts to safety, because it's got three people watching behind it. So, oh yeah, this is okay. You have any check? Yeah. You okay with that? So there is actually a reason why you want to give a break on the safety factors there. So how did Barbier come to his decision? Well, remembering that the key factors here are punishment and deterrence, what's going to deter? What's going to punish? What is the need for punishment and what is the deterrence here? And the thing is, as a non-operator, deterrence is very little except for one thing. And that is, maybe if you know you're going to pay a stiff penalty, you'll be much safer in picking who's going to be the operator for your investment. And so it's going to cause people to think, okay, this guy doesn't have a really good safety record. I'm not going to invest with him because I might be paying hundreds of millions or billions of dollars in fines and penalties. But when it comes down to it, after all this discussion, it comes down to MOEX paid about 90, and MOEX is innocent in 10%. Transocean paid $1 billion, and it was culpable in 30%. And so he comes up with a fine of 100 for 10% gets 90 million. 25% gets 159 million. And then when we get into the people at fault, that comes up into the $1 billion range. So when you look at it, you look at the liability factor, seems kind of predetermined. You look at the penalties, looks nice and lockstep. So that brings us to the end of our fun here today. Well, my fun with you. I do love questions. Anybody have any? We've had wonderful questions. I love questions. Yes, sir.
One more. What's your prediction in terms of the change in contracting strategy going forward as a result of this, binding against essentially the terms of the contract went out the window because of the period?
Well, that's a really, really good question, because Judge Barbier did look at that, and Judge Barbier upheld the contract insofar as actual damages are concerned, and the defense and everything. The only thing that he did not uphold was in the event that there is punitive damages. In fact, even though BP, and this is just a district court decision, obviously, he ruled, and this is maritime because it's a drilling contract, charter of a vessel. He said that even though BP is grossly negligent, it still has to indemnify for all the damages except for punitive damages or fines. So he upheld the contracts for everything except saying that it violates public policy. Now, I would mention that there is a really, really good article that you all ought to read in Loyola Maritime Law Journal talking about indemnity for gross negligence in these contracts, which says that Barbier is wrong and that the indemnity should even extend to those. It's a really good article. Might be listed in the bio there too. Somebody, yes, sir.
I know that the Deepwater Horizon technically was a vessel, but legally...
But that's a really, really good question, because...
Is it like a platform?
Because for purposes... That's a really good question. For purposes of environmental legislation, the power of the Clean Air Board to regulate it, it's not. And the Fifth Circuit ruled that.
It's not a vessel.
It's not. But it is a vessel for everything else.
Doesn't that come under the Lands Act, Outer Continental Shelf Lands Act?
It does.
Isn't that where that comes from?
No, but what? The Clean Air?
No, that it's treated as a platform to where it's got four imaginary legs sitting on it.
The way it works is that the Outer Continental Shelf Lands Act governs anything that's touching the seabed.
Right.
Anything that touches it. Vessels are not.
Okay.
So the question of whether it's a vessel or not determines whether state law or admiralty law applies. All under the umbrella. It's an umbrella statute. All under the umbrella because this is a federal enclave. Remember, the OCS is a federal enclave. It's like being on a military base. So everything is federal law there. The question is it federal admiralty law or is it state law because the Outer Continental Shelf Lands Act adopts in Section 1333 the law of the adjacent state?
Did AP get back a portion of their penalties and tax credits? Is that true?
I do not do tax law. I'm sorry, and I don't want to answer that because I hate tax. I've got to do my own and the firms and everybody else's, so I can't answer that and don't know the answer. I'm sorry.
The industry has gotten away with laws that have not been detected by the press or the public. You know, it comes to mind, they had one last year, right on the edge of the Gulf, high-pressure gas well blew. It had liquids. It ran for about 7-8 days, and then it yielded itself, which was great fortune for the company.
Mm-hmm.
There was one in Vermilion Bay from 15 years ago. It blew for about 7 weeks. Basically a gas well, but it had distillate, spilled oil all over the place. The press never got it, never caught fire. You never heard a thing legally about it. So, and then there was a well that was hit off of Marsh Island, way out in East Coast, Launch Bay. It was hit by a dredge, and it blew for 3 weeks. Reported to the Coast Guard, we fished in that area, never saw a thing, and it finally stopped. But it evidently wore itself out,
Yeah, you know that there's a real good lesson about that, and that is that it's nice to have money.
I was just wondering, the reduction from $13 billion to $5 billion for BP, is that just due to the fact that they said their entity,
It's a settlement.
so they just, but I mean, was it based partly on the fact that I'm saying, we can't afford it?
No, I don't think so. I think it's proportionality. I think the government knew all along what they wanted, and they knew that from the beginning. They got $1 billion from Transocean, and I think they were always looking for around $5 to $7 billion from BP.
Was part of Transocean the reason theirs was fairly high? Because they hadn't done safety checks and all in the BOP? Like their equipment wasn't up to speed?
I think it's because BP and others and the plaintiffs did a very good job of proving that Transocean committed a number of faults. They committed a number of serious transgressions, as did BP. BP's more serious. And so, if you're 30% at fault, and there's 130 million gallons, I think the government's going to take it's got to have a scalp on its belt.
Anadarko got off relatively light compared to the others. And to say that they don't have anything to do with the operation, it's true day to day, but they did have advisors who went out there and who would look at what was going on.
They're not advisors. They're people trying to figure out if you chunk in $38 million to the drilling, then you want somebody out there saying why you spent $38 million.
I think we need to clear out the room.
Thank you all.